Welcome to the Native American Forum at Cal Poly Humboldt and the Humboldt County District Attorney debate that's sponsored by the Criminology and Justice Studies program and the Sociology Department and the Politics Department at Humboldt Cal Poly. Yes, I am the chair of the Sociology Department. My name is Tony Salvaggio, and I want to thank you all for joining us. We have three great candidates here today. We're very pleased also to have permission to host this debate here in the Native American Forum. And I'd like to begin the night with an acknowledgement that we gather here today on the traditional land of the Wiyot, indigenous people past and present, and honor with gratitude the land itself and the people who have stewarded it throughout the generations. This calls us to commit to continuing to learn how to better steward the land that we inhabit as well. To recognize the land is an expression of gratitude and appreciation to those whose territory we reside on, and a way of honoring the indigenous people who have been living and working on the land from time immemorial. It is important to understand the long-standing history that has brought us to reside on the land and to seek to historical context. Colonialism is a current ongoing process, and we need to build our mindfulness of our present participation. Acknowledging the land is an important indigenous protocol that we are honoring here today. So thank you very much again for joining us, and thanks to the candidates for the Humboldt County District Attorney. Here with us, we have Adrian Kamada, we have Stacey, Eads, and we have the chair. Michael will maybe be here shortly for what should be an enlightening and lively 90 minutes of debate. The debate has been organized to really center student voices, and to that end, over the past few weeks, we've asked Cal Poly Humboldt students to send us questions that they have for the candidates regarding criminal justice and public safety issues and priorities, and how they would approach serving our community. And on that note, I want to introduce our two students who will be asking the questions to our candidates tonight. Alicia Manriquez, and we can applaud. Senior sociology major who, MSW? Yes, who's going to go to grad school. And then Natalie Zaucha. So once again, thank you for coming here and learning what the candidates have to say about some of these issues. And I'm going to now turn it over to Alicia and Natalie.
Hello. So we're just going to begin with some opening remarks, 2 minutes each.
Good evening. Thank you so much for hosting this very important forum. I'm Assistant District Attorney Stacey Eads, and I'm running for District Attorney because I have the experience, the integrity, and the ability to do the job. I have been prosecuting crime here in Humboldt County for over 20 years. I began most of my career focusing on juvenile justice and helping kids and assisting with rehabilitation and other programs, working collaboratively with other justice partners within our community, as well as getting an inside look at many of the challenges that the youth within our community face. Much of that is within their households, many of the challenges of substance use, violence, and neglect. Currently, I am the lead prosecutor of our child abuse and sexual assault crimes. In addition, I prosecute homicides, and as the Assistant District Attorney, I assist in the overall management and running of the office. The District Attorney's office has about 60 employees. It's the largest law office here in Humboldt County, and with Maggie Fleming, District Attorney Maggie Fleming, I oversee the overall management and running of the office and addressing the how we within the community, within the District Attorney's office, can address the needs of our community. I am honored to have had the opportunity to serve Humboldt County for the number of years that I've done so. I'm committed to my community. My family lives here. I'm originally from Humboldt County, and when I graduated from law school, it was my #1 priority to be able to return to Humboldt County and serve my community. I'm so honored to have had that opportunity, and as your next district attorney, I will continue to do so with the ability, the experience, and the integrity that I've done so from the beginning of my career. Thank you for this opportunity. I look forward to sharing more this evening.
My name is Michael Acosta. I'm assuming it's an introduction.
Yes,
Okay, thank you. I'm sorry for the late navigating campus. I am not from Humboldt County. I'm from Los Angeles, Orange County area originally. Did 6 years at Stanford, studied political science and law school there. Practiced in South Dakota and California in all areas of law. Was formerly general counsel for Bureau of the Tribe for 6 years. Worked at Acosta Legal Services as a managing attorney, and also at California Indian Legal Services. Since the last 10 or 12 years, I've been private criminal defense attorney in Humboldt County.
I'm just saying, makes me more comfortable. My name is Adrian Kamada, and I'm from Arcata. Grew up down 11th Street, and I graduated from Humboldt. I don't know if I say I graduated from Cal Poly Humboldt or Humboldt State. I can still say Humboldt State. I want to be the next district attorney because I love Humboldt County. I think that Humboldt County has so much potential, and it is being held back by the incredible skyrocketing crime rate. Over the last 5 years, the crime rate has gone up 30%. Statewide, it's about 10%. That's 3 times more than the state average. One county below us is actually having a dip in crime. So we need to make changes. It's time to do something new, and it's time to bring the district attorney's office into a modern era. That means that we look at alternatives to the traditional model that have proven to be absolutely more effective in reducing recidivism, the revolving door of people going in and out of jail, by focusing on restorative justice, by focusing on the underlying root causes of criminal behavior. And these programs that have shown such a great ability to reduce recidivism cost less. They're more effective and they cost less. 30% increase in crime. That's not what I want to see for my family growing up here. It's time to do something different. I have a son that's 3. I have a baby on the way. I want to be able, for them to be able to roll around Arcata like I did. On their rollerblades, the 90s are back. On their bicycles, have fun, play basketball, and not worry about the crazy scourge of crime that has taken over our community.
Mr. Acosta, could you please explain what racial justice means to you?
Racial justice, well, that would be blind justice. It would be justice where the statistics pan out, where maybe prosecutors consult the statistics as compared to what their offer is in the case, and make sure that their offer isn't something exceedingly above the average of what's being offered for a person of color, so that if the average person statistically gets a 5-year sentence, they better check that statistic before they give a person of color an 8-year sentence for the same crime. And I think that would be a useful exercise that is not done presently by the district process.
Okay, following up with that, could you please provide concrete examples of when you have actively worked to promote racial justice in Humboldt County or in the county you have been?
Well, I've always worked in poor communities from East Palo Alto, East Los Angeles. My assignment at Legal Aid Foundation of LA was East Los Angeles office, where we worked with immigrants and impoverished people. I went out to Dakota Police Legal Service to work in Pine Ridge, South Dakota, with the Native American people, oftentimes against their own tribe that was discriminated against them in tribal court. And there was a history of that out there in Pine Ridge. Worked with some Indian members. Recently in Humboldt County, I took a very unpopular case, David Anderson case, where I felt that the defendant was overcharged because he was black and achieved some decent results actually in Eads, and I worked on the case together, and she was very fair, and I achieved, I think, a fair result from Mr. Anderson. So that was in the paper. I think I'm on record as calling the prosecution racist prosecution at that point. So, but I regret that statement to some extent because it was a little inflammatory, but Ms. Eads was very fair in offering us a reasonable settlement. Mr. Anderson's our custody.
I think that race, absent a hate crime type of analysis, really doesn't have a role in terms of how we prosecute an individual who commits criminal behaviors. So I think that one thing that was really interesting is that a Yolo County District Attorney actually did some studies to see if there was a difference in terms of numbers when folks were aware or not aware of the race or the gender of the individuals that were involved in a particular criminal investigative report. And they actually found, it was very interesting, that there was no difference. So I thought that was really a key thing that intrigued me. But I also think it's really important to look not only at the defendant or the perpetrator or the accused in terms of his or her race and whether we're being fair, but also to always look at the survivors and the victims that are involved in the matters as well. So I just really want to highlight the fact that I have prosecuted a number of very serious sexual assault crimes, some involving children, some involving adults, and many of those have involved persons of color. So I've had survivors from the Hmong community. I've had survivors that were Black. I've had survivors who were of Native American ancestry. So, and we work together and we serve those folks very well. And I think it's important just to highlight that too, not always just kind of look at, are we being fair to the defendants? And are we also being fair to the victims and the survivors? And it was really interesting to me to go through jury selection and some of the biases that I actually found within individuals within our community regarding these particular communities. I remember one juror who actually said it couldn't be possible that this Hmong survivor's father sexually abused her because that doesn't happen in their culture or within their race. And I really just thought that was quite unfair to her to have that preconceived idea and decision. So I think it's really important to also highlight, are we giving justice to everyone that comes entangled and is involved in the criminal justice system? So yes, I think that absent a hate crime analysis, where it very much does become relevant, it has no role, and everyone has a right to fair and equitable justice.
So, I'd say that, first of all, there's no question that our Constitution and what's morally right proceeds on a fundamental basis that all people are equal before the law. Religion, race, ethnicity, those don't have anything to do with justice. But we can't ignore the fact that there's been injustice for a long time towards people of color. Disproportionately, the amount of people that are people of color in the justice system is something that is pretty shameful. The percentage of Native American people that are in custody right now is about 20 times their percentage of demographic. There are problems that we can't ignore. We must acknowledge the history, and we must do everything in our power to live up to what the Constitution stands for, which is equal justice. But that doesn't mean that we can ignore it. Now, in my job as a prosecutor, like Ms. Eads, I have had victims from all different backgrounds, as well as defendants from all different backgrounds. As a public defender, same thing. And I have seen cases that seemed unfair to me, like one in Arcata where the only evidence really suggested that... Oh, okay. I will leave it at that.
Mr. Acosta, do you have a rebuttal?
Well, I don't know if the skewed in a lot of states in incarceration terms. I think the demographic for Humboldt County is 11% Native American in terms of how many population of Native Americans. So 20 times that would be 220%. That's not possible. But I think that where you really see it is in sentencing, is where dispositions are made and people of color get harsher sentences. They get treated differently at the probation office. They get treated differently by the police after they've lost their rights. They've lost their search and seizure rights under the Fourth Amendment, they've lost their gun rights under the Second Amendment, and then they get the doors kicked in randomly, arbitrarily, capriciously. And that's where it really hammers home. And I think what's happening in America, not just this community, is we're evolving into a caste system where you have super citizens of police officers, you have normal citizens who are out of the system, and then you have people that follow the system who lose their constitutional rights and basically have a right to nothing, because anytime the police can walk into your house, take off what you have, arrest you, put a probation hold on you, you're basically a sub-citizen. So it's really a caste system development.
Thank you. Ms. Eads, the other level.
Thank you. I would just like to reiterate that indeed I think that everyone does deserve fairness and equity. And I'm also thinking as well, again, of another case where it was a young black woman that was victimized by a black man in a Dollar Tree store. And again, the conversation I had with a white male juror, he said she should have just left the store where she was victimized. He put it on her. So again, I want to emphasize that we need to give fairness and equity to everyone that's involved in our justice system.
Yeah, I'll just finish what I was going to say is that I had a client just last year that the only evidence in the case was that it was self-defense. But the DA's office refused to do anything or give any analysis and made this guy, who was a young black man in Arcata, made him stay in jail for 81 days until we got to jury trial, and then they dismissed it. Not being able to realize they didn't have the evidence the whole time. And I think it's really interesting speaking of David Anderson, and these two having come to a resolution in that, that is something, again, where race should not play into account. The disposition in that case is absolutely shameful. One of the women that was victimized talked about how David Anderson had victimized hundreds of young women. In that case, he had raped a young woman. And Ms. Eads entered a plea deal with Mr. Acosta that even everybody at the public defender's office was appalled by.
How do you address community's concerns surrounding racial injustice?
Yeah, so there's two areas I see that need improvement in that question. One is when there are officer-involved shootings or other egregious police misconduct cases, many times involving people of color, minorities, not always, sometimes involving core segments or disconnected segments of the white community. But in those cases, I think we haven't seen any justice recently. Usually the decision is made internally by the captain or the sheriff of whichever force it is, that whether or not there's going to be disciplinary conduct of the officer, and then within the legal establishment, the DA makes a unilateral decision. I think we underutilize the grand jury process. I think that gives people more power to decide in a case of police misconduct whether an officer should be charged with a crime, so that the people on the grand jury would have the authority to bring charges against an officer if they've abused their authority against any segment of the community, not just people of color, but any segment of the community. That's one area. The other area, to assure citizens that they're going to be treated fairly, and really you take race out of this question, because it applies to class too, really, and so it would be, and gender to some extent. In fact, reverse gender discrimination exists, believe it or not, in our system with charging cases. But my point being that I think the use of technology could be better to assist fact-finding, meaning that if the police wore body-worn cameras, there would be less court time spent bickering over what the facts were. And oftentimes they have them available, they don't use them, and the police are inaccurate, whether it's intentional or negligent, sometimes you wonder. But, and people get railroaded because of that reason. So if the community should be assured that I will set policies that require that the police wear those body-worn cameras, meaning I will tell the officers, if you don't wear your body-worn camera, I'm going to leave the citizens. I represent the people. The DA represents the people of the state of California. So why not leave your client, right?
So, what changes will you implement to ensure that minoritized communities feel safer? And how will you address the community's concerns surrounding racial injustice?
Yes, thank you. So I think one of the things that I'm definitely learning through my candidacy and the campaign process is how important it really is to speak with community members and to have an open dialogue regarding what are the concerns for various communities and sub-communities, if you will, and have those conversations. So one of the things I think will be really important when I'm the district attorney is that I will have open community forums and open dialogue so that I can hear the concerns that folks might have and what they're experiencing in their particular neighborhoods, what are the risks, what worries them, why they do or they don't feel safe, and what are their particular concerns. I think that really listening and hearing from our community and then addressing those particular concerns and having conversations with our law enforcement agencies, having conversations with the courts, having conversations with our other justice partners, including the defense. So I also think it's really important to have a lot of education and discussion. So I think those are key components to helping everyone have that sense of safety and having that reality of safety that we all really do deserve. And I also just kind of want to point out as well that in terms of the cases that Mr. Kamada commented on, the David Anderson matter, it had nothing to do with race, the disposition. The victim in that matter, she struggled a great deal, and the disposition was reached for her well-being and for her own ability to continue to physically survive. She struggles on the street, she has serious health issues, and it was done with her, for her really, not to put her through the defense, but through the trial process and having to testify and being cross-examined by the defense and be in the room with her rapist. So we really took that to heart, we listened to her, and we reached a disposition for her own welfare.
What changes will you implement to ensure that minoritized communities feel safer? And how will you address the concerns surrounding racial injustice?
Thank you. So, Ms. Eads is correct in that communication is definitely the starting point, right? We definitely need to have open forums. We definitely need to be present in the community as the district attorney, because to make this place safe for everybody, you have to build trust. And so one of the main roles of the district attorney is to help advise and train police officers. So having those trainings about implicit bias, about understanding different communities, that is a big part of what it takes to be the district attorney, what it takes to have the actual leadership. It is good, and it has to happen to speak with all of the members of the community from all diverse backgrounds, but there needs to be action as well. And that action comes through training the police officers, because when they build trust with the community, then it makes it easier for them to solve crimes, and it makes it easier for the district attorney to then prosecute those crimes. And I don't want to get stuck going back and forth on David Anderson at all, but I would just say that one part of the district attorney's job is to be a victim advocate from the start of the case. There are a lot of services that are available to folks, and you want to do everything you can to support them, and so there aren't hundreds of more young women that are attacked and raped by Mr. Anderson. So it is more complicated than that.
We're going to do a 1-minute rebuttal. Sorry about that. Starting with Mr. Acosta.
Well, just in 1 minute to address the David Anderson matter. That was a victim-approved plea bargain. The victim did approve it per the law, and he was only convicted of 2 counts of statutory rape. That's not rape at all, really. It's unlawful sexual intercourse with a minor for lack of the ability to legally consent. So that's different. You have to remember that most of the United States has now lowered the age of consent to 16 or 17. We're in the minority states now. So I think it was a fair resolution.
So I guess I'll just address the David Anderson case as well as the other case that Mr. Kamada mentioned earlier. In the earlier case, Mr. Kamada, I guess what he doesn't understand is when the district attorney found new evidence, there was an additional victim statement that indicated that it wouldn't be appropriate to continue to prosecute that case. Out of fairness and justice, the people then dismissed when we learned additional information. So that's the right thing for the district attorney to do. In terms of David Anderson and sexual assault cases, Mr. Kamada has not handled those cases. He can't begin to tell you how complicated and complex these issues are. I've handled sexual assault and child abuse crimes for years. I've worked with hundreds of victims. So how dare he even begin to suggest that he understands the complexities that are involved with these primarily young women when they're raped.
I just bring up two things here. First, I do handle sexual assault cases. We actually have 2 cases against each other right now, so that's pretty interesting. My point there is that the DA's job is to do what's paramountly the most beneficial thing for society. And allowing a person who has human trafficked people over and over and over again because the DA's office did not get on their job and take care of the victim from the start, and that was the reason that she didn't want to testify, that is a failure of our system for victims. So that is the point there. And when we're talking about racial equality and those issues, it does not matter what the race is when somebody is committing a crime.
So it has been 5 years since the murder of Cal Poly student Josiah Lawson. Conclusive DNA evidence has now been identified on the murder weapon. If you are elected DA, will you prosecute the Lawson murder case?
I will absolutely evaluate the evidence, and if the evidence is there, I will prosecute it. It's a horribly tragic case. What's really important for everyone to understand is the fact that the prosecution has already gone through preliminary hearing stage on one occasion, and there was dismissal because the judge found there wasn't sufficient evidence. We can only bring it before the judge one more time. And if we don't have enough evidence to do that, we will not be able to find justice for Josiah. We will not be able to find justice for Ms. Lawson. We will not be able to get the killer off the streets. So I think it's really important for folks to understand that we must tread very cautiously. Currently, the Attorney General's office does have the case under review, and that is at the request of both the Arcata Police Department, Chief Ahern, as well as the District Attorney's office. We are hoping that they can help us assess it and help us address that DNA evidence. And we will absolutely prosecute it. I want to get Josiah Lawson's murderer off the streets.
It has been 5 years since the murder of Cal Poly student Josiah Lawson. Conclusive DNA evidence has now been identified on the murder weapon. If you are elected DA, will you prosecute the Lawson murder case?
So this is, I've spent at least 5 hours with Charmaine Lawson and members of her Justice for Josiah Committee discussing the case. And what I've made very clear is that I will do everything possible, including coming up with new investigation techniques if necessary, but I can't make a commitment that I can prosecute that case unless I've seen the entire case file. I know everything that is happening in the case. Because as someone that's done homicide trials and has won every homicide trial that I've been in, it turns often on very small details. So I need to know all of those details before I can say confidently. I know that people want to hear me say, I'm going to go do this. I wish I could say that, but I will always be honest with you. And that is something that we need to understand here is that this case is in the DA's office right now, and the tune's kind of changing, saying, "Oh, we're going to go and prosecute it." Well, what are you doing today? What have you been doing for the last couple of years? So, I think we need fresh eyes, and I think we need a fresh take at our criminal justice system, and that's why I'm running for district attorney, because the old ways of doing things do not work. And I'm, speaking with Charmaine over and over about this, she understands my position on it. She texted me just before we got here and was very encouraging. She's supporting me in running for DA, and so I hope that we do get justice for him, for her son, but I will never say something just to get a political gain or to gather votes.
5 years since the murder of Cal College student Josiah Lawson, conclusive DNA evidence has now been identified on the murder weapon. If you're elected DA, will you prosecute the Lawson murder case?
So yes, absolutely, I would, and I think when you say prosecute the Lawson murder case, there may be more than one prosecution involved, more than one person involved, and you may have to bring some of those other charges against the accessories or accomplices to leverage more evidence in the main murder case. Of course, there's no statute of limitation on murder. It's not true that you only bring a murder case twice. In fact, I was involved in a murder case in this county, People v. Nick Legal, in which the people effectively brought charges 3 times against Mr. Legal, and he was falsely accused of murder. He was later, he was not acquitted, but the charges were all dismissed against him. So I think if there's significant new evidence, it's time to bring charges back, and whether you do that through the complaint process or the grand jury indictment process is an open question, but absolutely yes, probably against more than one person, the charges will be brought.
Thank you. Ms. Eads, do you have a rebuttal?
I just want to say that in terms of the DNA evidence, I can't really comment on the details of this. There is a bit of a potential question as to the premise of of your questions. I just want to note that for everyone's understanding. And also, I just want to make it really clear that we do have to have sufficient evidence to proceed. So to get beyond the preliminary hearing stage, there has to be sufficient evidence to hold the person to answer to the charges that are brought against them. If there isn't enough evidence, then the court will dismiss the case of the charges that are upheld. And that is a much lower level than beyond a reasonable doubt that we have in terms that we need to sustain a conviction. So what I want to be really clear about is that there has to be enough evidence, and people out there might have more evidence. If you have the evidence, bring us the evidence, please.
Thank you. Mr. Kamada, do you have a rebuttal?
Well, I agree with the premise that a preliminary hearing is a lower standard of evidence. Ultimately, we need to bring the case beyond reasonable doubt. And that's why I say that I will review that case independently. And what I've also told Charmaine is that I'll bring someone in from another jurisdiction to another attorney to come, and we will work on it together to bounce ideas off each other so we don't end up in a situation where we can't prove it, even at the preliminary hearing, which happened last time, and then it makes it almost effectively impossible to bring the case back again because there is a 2 dismissal rule. So again, we are going to look at all the evidence, and again, from trying murder cases, it is very important that you know all the facts because it can turn on the smallest detail.
Thank you. Mr. Acosta, do you have a rebuttal?
Yeah, I mean, I think that there's a lot of stalling in this matter. I think there's plenty of evidence to proceed on. I think that if he was a white person that was murdered by a black man, probably everyone at the party was in charge, at this point. So it's I don't agree that we have to proceed cautiously here. The district attorney throws charges around all the time, overcharges cases to force people to plea bargain to something smaller. So why hasn't there been some action? I don't know. I'm not part of the district attorney's office at this point. So. We've done something already.
So, Ms. Eads, the current DA has stated that she will only prosecute the Lawson murder case if new evidence emerges, such as an eyewitness account. Taking into consideration the fact that eyewitness accounts are often flawed, why is DNA evidence not sufficient to move this case forward?
Again, the district attorney asked the attorney general to review the case. She also has taken it to the grand jury. They found there wasn't sufficient evidence for an indictment. The court, the judge, found there wasn't enough evidence to hold him, the suspect, to answer on the charges. The new attorney general has accepted review of the case so that they can do their own analysis, and perhaps they have additional investigatory tools that might assist in the analysis of evidence as before. I think that I don't know the particular quote that you referenced, but what everyone really does need to understand, again, is that in order to proceed, there has to be sufficient evidence. If there's a dismissal at the preliminary hearing stage, we're dead in the water, and we will not have justice. And that needs to be really clear. Hopefully, that the Attorney General's review will be able to assist, and that there will be sufficient evidence, and there perhaps will be additional investigative tools. Perhaps someone will come forward. There have been lots of rumors about different things, but nobody came forward with those particular items of evidence that would help prove the charges. So that's really what's needed, is in order to have sufficient admissible evidence to prove the charges.
Question regarding the fact that the current DA has stated that she will only prosecute the Lawson murder case if new evidence emerges, such as an eyewitness account, taking into consideration the eyewitness accounts are all too flawed. Why is the evidence not enough in your opinion?
Yeah. So, make a couple real quick points. The first one is that previously the district attorney's office had referred it to Department of Justice, the Attorney General, and they sent it back. This time around with AG Bonta, it's been Charmaine that brought that case to him, and she went and met with AG to see if there's something that they can do. And if it's the idea that there might be some new investigative techniques or something like that related to DNA evidence, why hasn't that been done? Why are we still, talking about this? If that was available, we should have reached out to those experts and found them, if that's what it comes down to. If it is only now a situation where you need an eyewitness, I think you're going to have, from what I know of the case, again, talking about the details, all of them matter, that there was a variety of different statements, so it makes it difficult to see exactly what the sequence of events were. But, from my understanding of the case, it does sound like there is a prosecutable case there, but again, I can't make any promises to anybody without being able to know every single detail, every single statement, all of the physical evidence that was taken during that investigation.
Thank you. Mr. Acosta, do you have anything to add on that note regarding the eyewitness account?
Well, yeah, I think that there's a lot of people in death row right now because of false eyewitness accounts. I think DNA is obviously stronger. I support the death penalty. I know that might be an unpopular position, but I do it with a caveat that it would have to be with DNA evidence. Most of the people that are falsely convicted or on death row either didn't have the DNA evidence because it was before that time, or the judge denied them the ability to present it. If you're saying that we have DNA evidence on a murder weapon, what better evidence do you need? Eyewitness accounts are probably more flawed than that, obviously more flawed than that. So why hasn't there been action? Punting to the AG's office is a cop-out. It's passing the buck. The DA locally should be handling it. You only go to the AG's office if there's a conflict for the prosecutor's office. If the district attorney has a conflict of interest, she would pass it on to the AG's office. What conflict does she have? Is there a conflict we don't know about that she hasn't stated? Because it should be at the Attorney General's office. It should be locally here in Humboldt County and being prosecuted.
Thank you. Ms. Eads, do you have a rebuttal to that?
Yes, so a couple of points. One, the AG's office is doing an independent review. It's not a matter of whether they'll prosecute the case, so it's a little bit a different role than perhaps Mr. Acosta is otherwise familiar with in terms of what the AG's office might do for us. In terms of who presents the case and who takes it, I'm a mother of 3. I cannot begin to imagine the loss of my child. The tragedy and that Ms. Lawson has suffered is incomprehensible. But that understood, she's not the person that has the evidence. She's not the person that's taken to the Attorney General's office. I have no doubt that she's advocated on behalf of her son and wanting justice for him with the AG's office, but she's not the one that took the evidence and takes the case. That would be by the law enforcement agency, so in this case, the Arcata Police Department, and with the joint request of the District Attorney's Office. So I want everyone to understand that as well.
Thank you. Mr. Kamada?
So one of the biggest things about that Lawson case, I think, is 2 things that really should happen as a matter of leadership from the District Attorney's Office. The first one being, when you have a case of this kind of tragedy that has this much significance and this much interest from all members of the community, it should be the district attorney, the elected district attorney, that handles that case all the way through. After the murder of George Floyd, AG of Minnesota, he sat at that table with special prosecutors because it was a symbol of how important this is. This isn't something that you pass off to a deputy. It's something that you handle. So it shows the importance to the community about what matters. And the second part is that when a district attorney, after 5 years of what we've seen go back and forth, and Charmaine's struggle to get answers is that there's a fundamental problem with the communication that's happening out of the district attorney's office. Yes, there are things that you can't talk about because of an investigation, but clearly the messaging, the speaking with Charmaine so she understands what's going on, that did not happen, and that will change around the district attorney.
Thank you.
I think that obviously something should be done here. I agree with Mr. Kamada. There has to be leadership locally. Whether the Attorney General is just in an advisory role or not, it still indicates that it's not high priority for Ms. Fleming's administration. I think that's unfortunate. I have lost a son before, and I can relate to Ms. Lawson because no closure, you only learn to cope better in life. It's a burden you carry for the rest of your life, possession. So I can understand Ms. Lawson like that, and I just think there should be something done.
Thank you.
So if elected, what programs and policies of the current DA would you keep and roll back? And what reforms or structural changes would you make?
Well, there needs to be a lot of structural changes. And they need to be done incrementally, because change that is sustainable, that lasts, you can't just blast it and all happen at one time. So we need to start adopting programs and doing it in a pace that those programs have a chance to succeed in our community. I think first thing is that we know that the way that things are going right now don't work. Crime's up 30% over the last 5 years under the Eads Fleming administration. That is just the facts. You can feel it, you can see it. So what are we going to do about it? Start thinking outside the box. Start taking programs from other jurisdictions that are working. And one of the, I think, the most fundamental things we can do is start a first offender program. This is where we have the best chance to head off long-term crime. When you have someone that's, between the age of 18, 25, somewhere in there, that commits a felony offense or a misdemeanor, a low-level felony, nonviolent type of offense, let's divert that person from the criminal justice system. Let's steer them away from the criminal justice system. Because if we do that, one, we can make sure they're actually held accountable through community-based programs, look at encouraging treatment for mental health or substance abuse. What we do by sending a young person to prison on a low-level felony offense is basically invest $100,000 a year in making sure that person becomes a more sophisticated criminal that comes back into our community and perpetuates crime over and over and over. So we need to look at these models that are working elsewhere and adopt them here. The old ways of doing things, the way that they want to continue doing things, has only led to skyrocketing crime and a loss of trust with our community. So, as a district attorney, I will implement structural change and cultural change to that office in a way that holds people actually accountable and is fair, protects the public and the victims at the same time.
Well, I think structural change, yes, hold them accountable. The part of the lack of accountability in this country, and definitely in this county, is the informant reward system, in which police use certain categories of criminals that don't make profit for them and exchange those crimes for the for-profit asset forfeiture cases. It's policing for profit. That's the reality. Nobody wants to hear about this, but this is the reality, is that the FBI authorized 22,000 crimes over the last 4 years, up to and including involvement in murder. But those crimes that they let go weren't the profit-making cases. So let's talk about policing for profit and structural change there. Let's talk about categorizing property crimes equally to drug cases, okay, or child molestation cases equal. You know what? Why don't they do asset forfeitures on child molesters? They use their house and their car to commit their crime. Why is it only drug cases that they do asset forfeitures on? You either equalize the asset forfeitures across all categories of crime, or you eliminate asset forfeitures entirely and take away the profit motivation for policing. That's what you do to fix America. And that's why we have more incarcerated people in America, but we're not even in the top 10 safest countries in the world. Because why is that? Something we're doing wrong. And it's policing for profit. We're allowing it to go on and on. This locally, they don't even track statistics of informant rewards and who gets let off, allowed to do crimes, authorized crimes. They call them otherwise illegal activity is how the FBI categorizes those. Okay? So if we're not tracking them, we don't even know what the statistics are and how many crimes are being condoned by the police and the DA's office making these deals in exchange for making that case, getting that buck in the case that they can make the buck in.
If elected, what programs and policies of the DA would you keep and roll back? And what reforms or structural changes would you make?
Okay, thank you. So I think one of the things that's really important to note here is in terms of the crime that every one of us sees on a daily basis. So a lot of these theft crimes, sadly we're seeing lots of folks that are houseless, and there's a lot of vandalism, there's a lot of destruction of property. The people that Mr. Kamada here has referenced in terms of young, first-time offenders, low-level offense, these people are not going to prison, okay? That's a total misstatement. That's not happening. The changes that we face in terms of from the legislative changes really tied our hands as prosecutors in a large part because some of those repeat offenders, folks that we do need to have hold accountable that repeatedly steal from members of our community, repeatedly commit theft offenses, second-degree burglaries, those no longer are individuals that legislatively, statutorily, we can't even send them to prison. Those crimes in and of themselves aren't eligible for prison commitments. They might have to serve some time in our local jail. A local jail has become somewhat of a mini prison because of the number of responsibilities that the state shifted to the local county in terms of addressing offenders. So the first-time offenders, very few of the folks that we even see within the justice system are first-time offenders. As prosecutors, we look out for the rights of everyone. So not only do we look out for the rights of the survivors and the victims, but we also look out for the rights of the accused. And in doing so, we try to figure out what's fair, what's an equitable outcome. And so we look at a person's criminal background and whether they have one or if they don't have one. And we also have a number of diversion programs that have already been on the books. The laws in terms of statutory programs. There's the veterans diversion, there's mental health diversion, there are diversion programs for folks that have substance abuse issues, or possession of narcotics and illicit substances programs. There's, and even beyond just diversion programs, there's the drug court program, which does involve a conviction and it's a type of probation where there's intensive services and success with the drug court program. It's really a great accomplishment, and then it results in dismissal of the charges. These are great things that we've had in place and that we utilize those, and so we'll continue to do that. And I'll continue to engage in an analysis that's fair and equitable, and I will talk to our legislators, and I will have those conversations to change those laws back so we have the tools that we need to hold people accountable.
So, I've worked in the district attorney's office for 6 years with the Eads. I can tell you that the waste of resources and time because we try to be tough on crime by saying, open plea, we're going to argue for prison when we all know it's not going to happen. It's a waste of resources. What I'm talking about is working with these programs, making decisions from the beginning and saying this person should be diverted so we don't have to go to court every 6 months trying to get a courtroom for the case. So they can push off the responsibility on the judge because they don't want to be what a district attorney is, which is the gatekeeper of the criminal justice system. The district attorney needs to be someone that not only will make the decision and say, I'm making the decision, I'll live with the decision, but they also need to be a leader in the community. They need to be working with the Department of Health and Human Services and not be treating it as 2 separate places in 2 different silos and not communicating in a way that has meaning. And when I talk about that, it means that the Department of Health and Human Services counselors that get scared when they have a mental health person that's off their meds, we provide an investigator with special training to help them. We write grants together to get services and expand because we're not going to make this community safe unless we deal with the substance abuse and mental health problems that are all over the place.
Mr. Acosta,
Sure, I think that there's some simple solutions here. One, you treat addicts like patients, not like criminals. That further puts barriers in their reintegration in society by making them unemployable and stigmatizing them and putting them into financial debt. Treat them like patients. Look at Portugal, 20-year baseline experiment, successful, most successful in the world probably, okay? With recidivists, you can exile them, you can banish them, no one thinks about that. We can just take someone who's a chronic petty thief and say, you're going to do 5 years out of the county or 5 years in jail. That saves us money and gets rid of the person for 5 years. I think it's fair because CDC has done that to Humboldt County for years, dropped off an inordinate amount of parolees up here. So I think that's a remedy that no one looks at, is banishment. And there's a solution. And then you go hard on, very hard, and you have more resources to go hard on the violent crimes and the sexual assault cases. Reprioritize.
I would just state that throughout my over 20 years of prosecuting, I've diverted many cases, and I look at cases individually and independently, so I'm not exactly sure what Mr. Kamada thinks that he's going to do that's so new. This is something that we've been doing for the entirety of our career, and taking an analysis and taking considerations. I also will follow the law. I have concerns regarding the banishment proposal. I think that would be entirely unconstitutional and unlawful, so I wouldn't even begin to think of going there. So it's very important that we continue to serve with integrity and looking at everything in a fair and just manner, and to make those good, solid decisions that can be made based upon experience and good reason.
How would you encourage community participation in law enforcement oversight?
Law enforcement oversight, yes. Well, that's a very good question. I think, as I've said before, any institution that has the authorization to kill and the political position to get away with murder should have civilian oversight, very similar to the commander-in-chief being over the military in this country. Should have civilian oversight of police. They're not going to do it to themselves. We've asked them to in many communities. They say, no, we're going to do our own internal investigations. And you know how that works out. So I think the district attorney's position is the key point. It's the bottleneck in the system where the people can get involved. And again, I would bring up the criminal grand jury indictment process for police misconduct and officer-involved shootings, where the people can sit on a grand jury and decide and have a broader base of input on whether officer misconduct should be charged, and there's your community input. And then there's traditional forms of meeting with the community, of course, but that's a non-controversial area, which I don't like to talk about non-controversial areas. Talk about the cutting-edge stuff, what's going to be different. And so I think the grand jury process criminally is underutilized for those cases. I think Ms. Fleming is basically made a unilateral decision in almost every officer-involved shooting case, and that's a tragedy.
Thank you. Ms. Eads, would you like me to repeat the question?
Yes.
Okay. What would you encourage, or how would you encourage community participation in law enforcement oversight?
So again, I think it's really important to have education and involvement and to have those community open forums and discussions. And so I would want to continue to hear from the community and hear their thoughts and have their input. I do want to note on the officer-involved shootings and make it very clear, nobody has a permission to murder. It doesn't matter if they're in law enforcement. That's absolutely a misstatement. No. The officer-involved shootings, yes, there's an administrative review that's done by the officers that are involved in the shooting, that's done by their agency. That's separate and different from a potential criminal investigation that's led by the district attorney's office, and in certain cases, in particular if it's an unarmed individual who is killed, then that will bring in the Attorney General's office, and they will take the lead in the investigation of those particular cases. So I think it's an entire misstatement and an absolute misrepresentation to say that law enforcement officers have permission to murder. That is not true. They will be investigated thoroughly, and there will be a very careful analysis that's done, applying the facts, the evidence, to the law that applies. And what's important to do with that analysis is to outline all of that. And there are, sadly, occasions when charges do have to be brought before law enforcement, police officers that make the wrong call and do commit an unlawful killing. And that is one of the greatest tragedies that the people that we've entrusted to serve and protect us unlawfully kill another. So I absolutely would
would prosecute a police officer in those circumstances, and that needs to be made very clear as well. Thank you.
Thank you.
So, for law enforcement oversight, I think, well, going back to one of the fundamental things that really needs to be robust is body-worn cameras. So everybody can have essentially an objective view of what happened. As we talked about review of the district attorney on law enforcement involved shootings, we need to be truly independent. That is what the district attorney has to be in those situations. And in my experience with this district attorney's office and the continuation of these same policies is that they defer to law enforcement way too much. They're scared of offending law enforcement. And that's different from building a solid relationship with law enforcement, but there's situations where they've just bent over backwards to not offend law enforcement when they did it at the peril of what was right. And that is going back to what is fundamental here, building trust with the community. And so having an oversight board that is in a way that actually has authority to look at the evidence and records, and one that it doesn't become a political battle. I think all that does is help build trust with the community, what ultimately makes law enforcement's job a lot easier. Because most of the law enforcement, all the law enforcement officers that I know, want people to understand that they're here to protect and serve, and that they care. And when they have these situations that are happening where this trust is built over really sad events, that makes their job harder. That makes the DA's job harder. So building trust is what we need to get back to, and if that takes having a citizen oversight board that is effective, I think that makes sense.
I never said that police were authorized to murder. Murder is a malicious homicide, so it has to be both elements. Police do have authority to use lethal force. They're authorized to use lethal force, and what I said was that they are in a political position to get away with murder because they can turn off the camera and they wear the uniform, which makes them somehow more credible than the rest of us. So that is what I say there should be civilian oversight. I think the sad reality of what Mr. Kamada says is that DA, this administration, and I don't blame Ms. Eads, she is not Maggie Fleming, she's an entirely different person, and that's unfair of Mr. Kamada to group her at the Eads Fleming administration. But I think that this administration and Ms. Fleming has not prosecuted police for stealing dead people's property. That happened, there was a scandal in the North Coast Journal, and no one's been prosecuted in that because of her relations with law enforcement. She didn't want to offend anyone in the departments. So she punted the Attorney General's office, said there was a conflict. She doesn't represent the police department, she represents the people. There's no conflict of interest. So that's what Mr. Kamada's point was, that it seems to be the relationship, she doesn't want to taint their relationship for whatever social reasons, so she doesn't go after the police. So I think that should end. She should represent the people.
You have a rebuttal, Ms. Eads?
Again, I think that it's really imperative that we, the public, are able to have the trust of those folks that are serving to protect and enforce the laws. And so I think to continue to serve with integrity and honesty about the actual facts, applying the law that is handed to us by our voters and our legislators, and making those decisions based upon law and fact, not sentiment or special relationships or commitments to other entities or organizations is what we need to do. So serving with integrity based upon the fact and the law, and if we do that in an open manner, then I think that we should have the trust. And I really do want to say that law enforcement officers are oftentimes working hand in hand with the community, and they really are doing it because they want to serve and they want the best for their community as well. Sadly, there are occasions where folks are just making bad, poor decisions, and it affects everyone. So.
Thank you. Mr. Kamada?
Thank you. First of all, I think that this is great. Yeah. Communication all that stuff. Yeah, we need to do that, right? But we need to take action. And the reality here is I've been saying these same things about having police accountability, having oversight. And I have far more law enforcement backing my candidacy as a public defender than any of my opponents. So that tells you a lot about they also want to have accountability because that builds the trust, going back to that point. And so when we have a relationship with law enforcement that is one of respect, but understands that we have separate jobs, and sometimes we have to review their actions, we should do that as independently as possible, and also have the Attorney General review that as a second opinion.
Thank you. But the Yurok tribe has been seeking the Humboldt County District Attorney's Office agreement and implementing a diversion program that would allow some felony offenders to enter into diversion agreements overseen by the tribal court. If elected, would you support such a program? Why or not?
Yes, and actually the tribal diversion program that the Yurok tribe has been working on in collaboration with the district attorney's office and also with the courts, it is more than just the felonies, so it also involves diversion programs for misdemeanors as well. The program or the memorandum of understanding is something that I've actually been to a number of the meetings regarding that, and we are very much appreciative of the fact that folks that might be diverted through a tribal diversion program would have access to many more resources and services than they might otherwise if they're limited to those resources and services through the county programs. And within the tribal courts, they actually have oftentimes a probation officer or officer that works really closely with the individual that's been charged with crimes, and they would be able to help them get into various programs to address perhaps substance abuse or mental health issues, and help them out as well as with housing and restorative justice type programs as well. So I think all of that is really beneficial. One of the kind of roadblocks that we recently faced was a question that came from one of the judges, because we had a recent change in who was the presiding judge, and the judge had concerns regarding whether there was statutory authority to allow the diversion to the extent that the agreement was contemplating. So we're currently in the works of rewriting and redeveloping something that would be, of course, lawful and also highly beneficial to the individuals that would benefit from such a program. So to answer your question, absolutely, we just need to do so in a lawful manner and in a way that the courts would also be on board with those programs and honor it as well.
The tribal diversion, I've spoken with the Yurok tribal court, and they're not all that thrilled about where things are after all this time of working on a memorandum of understanding with the DA's office. I think that there's a bit of a misunderstanding to some extent here that the DA doesn't have the authority to do what is, I think, fundamentally the right thing, and that is for most low-level felonies and all misdemeanors, essentially, go to the tribal courts for the diversion there, because they have far more resources, it's far more accountable, they check in about every 2 weeks, they have counselors, they have the resources to do it, and it's more accountable than a paper conviction and a couple days in jail. And so we should be doing everything we can to support that program. And I think one basic kind of understanding is, we're here in the Native American Assembly here on Wiyot land, is to remember that the Yurok and the Hupa and other tribes here, they have their own sovereignty. We should be looking at through a prism of it's supporting their government to do everything for themselves everywhere possible. Because self-determination is a fundamental part of international law and of the Constitution as it was built. And we have to remember that. And while there's a really long, sad history, I think it's time to move in a direction that cedes as much resources and authority to the tribal courts to allow them to succeed.
Well, I don't specifically know about the UROC MOA. I did represent Bear River for 5 or 6 years as a House Counsel and their gaming director. I also worked at the Oklahoma Sioux Tribes courts for a number of years, 4 or 5 years. And that is a non-public law treaty state. If you're familiar with public law treaty. California is a mandatory public law treaty state. So that makes it a little different than other states. But I can say this, it depends on what we're talking about here. I'm not sure if we're talking about pretrial diversion or post-conviction diversion. Are we talking about deferment of the prosecution? Are we talking about transfer of the entire jurisdiction to the tribal court? So I think we need to find out a little more, but absolutely having experienced a full tribal court with a jail and a tribal law enforcement system where the state cannot be involved, which is Pine, South Dakota, Rosebud, South Dakota, all those reservations out there. It can work. Absolutely it can work. In Pine, South Dakota, there were no state police. There was federal government and the tribal government. That was it, and it worked fine. So it can be successful, but we really need to define whether we're talking about transferring the entire case for prosecution, or we're talking about deferring the state prosecution so the tribal court can do some sort of social services diversion, or whether we're talking about a post-conviction sort of probation department of the tribe. And as long as those roles are defined, I think it'll be fine. I would support this.
Stacey, you have a rebuttal?
Sure, just to give a little bit more information regarding the diversion programs that we're working on with the tribes. And I just want to note too that the Yurok tribe is certainly taking the lead, and so we're developing the MOU, but the intent is to also have that as a model for other tribes. So for example, the Hupa tribe, they have some really great behavioral health services. They're lined up and they're ready and they're waiting for patients and folks that they can help serve. So it's really exciting once we have those programs and the agreement in place. Again, that was a bit of a bump in the road with the new change in the courts and their view in terms of what was lawful and what was not. And so I think once those things are fine-tuned, we'll be able to proceed forward with the tribal diversion programs and serve the community very well. And the other thing that's really important to also note that protection of the community, safety, that's the #1 priority for the district attorney. So in assessing what types of offenders and what types of crimes would be appropriate to divert, and it is after the filing of the charges, but pre-conviction diversion that we're talking about here. So, so the person could potentially avoid actually being convicted of those crimes if they are engaged with the program and they follow the plan that's developed. Then they could get dismissal of those charges, and really that's a win for everyone.
All I'll add is that I think folks, if you have a question about this, talk to the attorneys and the judges in the tribal courts and ask them how things are going, working out an MOU with the current administration. We need actual leadership to get things done, and it's not happening under this administration. These delays are unacceptable. We need to create the programs as a supporter of the tribal courts. And yes, public safety is ultimately the key thing at the end of the day, but all of these pieces matter to creating public safety. Getting the right social services to get people on an exit ramp in the criminal justice system is the only way we are going to deal with the crime in our community.
Again, I go back to public law committee. People have to understand that the tribes still have concurrent jurisdiction to prosecute originally without the state court decision any crime over a tribal member or an Indian. That's federal Indian law. That's the status of federal Indian law right now. So they're free to prosecute if they want to prosecute, as long as the person is Indian or tribal member. So I'm not saying there should be more prosecutions necessarily, or double prosecutions, but that's the status. Whether the state relinquishes its jurisdiction because of their invocation of their jurisdiction is another question. So I think maybe the people involved in that MOU development should get some consultant on Public Law 280 and they would be able to maybe figure it out a little better.
Now we will have each candidate provide us with a closing statement, so you each have 2 minutes. We can start with Mr. Acosta.
Well, I appreciate the opportunity to be here and share these ideas with you. I think this election should be about ideas, not personalities or name recognition or money, who has the most money. I'm not accepting any political contributions. You can be assured that I am not bought by the police. I'm not bought by any special interests in this community. We're running a shoestring budget grassroots campaign to get these ideas out. Win, lose, or draw, I think it's important to introduce some of these ideas I have into the American political discourse. So I appreciate the opportunity to do that. I think you have 3 good candidates up here. I think experience as an overall attorney counts. I've been practicing 20 years. Ms. Eads has been practicing 18 years. Mr. Kamada has been practicing 7 years. So I think, I don't know that I would have run for DA at 7 years, though Mr. Kamada does have some good ideas too. So I think we're all 3 worthy candidates, and I like the fact that we're keeping it all above board. It's been a very good election so far. So I appreciate it. And thank you.
Thank you. Thank you so much for the opportunity to speak with you all this evening, and there were some really great questions. I'm really appreciative of that opportunity to address those questions and concerns. As the Assistant District Attorney, again, I have over 20 years of experience. I was licensed to practice law in 2001, and I returned to my community because I wanted to be here. It's where I grew up. It's a place I love, and it's a place where I want my family to be able to have the same sort of rural lifestyle, surrounded by people of a diverse set of thoughts and beliefs, and also just to have the access to all of the beauty that we have, so the rivers and the oceans and the mountains. And so it's a tremendous, wonderful place to live. But we really do also need to have a right to feel safe and to feel protected. As the district attorney, I will do my best to ensure that every member of our community has that safety and that protection, that we can really enjoy our community the way that we ought to be able to do so. I think with the experience, the integrity, and the ability to make decisions with good reason, following the law, looking at the facts, making a fair and equitable determination whether charges are filed, what's a good resolution, how can we achieve justice in each and every individual case in a fair manner, and to do so efficiently and always take into consideration the rights and the considerations of the survivors and ensure that they have a sense of justice.
Thank you, everybody, for your time today and listening to all of us. What I can say in terms of experience is, yes, they both have 20 years experience. I do have 8 years experience. I started prosecuting homicides after 2.5 years. I'm not sure that Ms. Eads has ever prosecuted a homicide, but we started doing felonies at the same time. She had 14 years in juvenile, which I'm not questioning. I think is a great experience and all of that. But when it comes to major crimes and stuff, the amount of experience here is pretty equal. What really matters is new ideas. This is what, the Times Standard, when they made the endorsement for me, they said, yes, Mr. Acosta and Ms. Eads have more experience, but it's time for leadership. And there's one clear leader, and that is what we're going to do, because 20 years experience doesn't matter if we're going to continue down the same path with no new ideas with 30% increase in crime rate. It is time for a change. It's time to think outside the box and follow some of the examples that other communities have done to reduce crime, which is look at this problem not in a silo, but look at it as systemic reasons, to look at actual solutions. And not put your hands up and go, oh, the legislature's made it harder. Okay, let's get back to fundamental problem solving. How do we fix it? Because I haven't heard one single new idea from this side. I've heard complaints, and I've heard everything's kind of going okay. It's not. And I, too, have a 3-year-old here, and I have a baby on the way, and I want this community to be safe for them, and I want it to be safe for everybody in this room, and I want everybody here to understand that they can trust their criminal justice system. Let's get back to that. Let's be accountable. Thank you.
I want to thank our candidates for spirited debate today, and thank you all for joining us. The mail-in ballot, when is the election? June 7th. And in terms of registration, the last day to register is?
We do have same-day registration also on elections.
Okay,
Thank
so
you, Roger.
Voting from May 9th to May 23rd.
great. So get out to vote.